Well, good morning everybody. In the link below today, I will leave in the description the link to Andrew Whitehead's video channel. Andrew Whitehead is just new to the Making a Murder YouTube discussions. It's always great to come across people who feel so incensed by what they saw and what they've since discovered about the complete lack of any kind of a justice system in operation in the case of Steve and Brendan. Of course, perpetrated by, in particular, one of the most perverted people ever to walk this planet, Mr. Ken Kratz. So as I say, it's always great to have new people coming forward doing videos. We know for a fact that the Guilter community absolutely detests people talking about the case, creating interest in the case. Well, guess what, Guilters? It's exactly what we love doing. You know, it's not that we wake up every morning thinking, how can we undermine local government in Wisconsin? What can we do to bring justice for Teresa, Stephen Avery and Brendan Dassey? Anyway, we're going to carry on now. If I'm quick enough, we could get through the whole of the final part of Judge William Griesbach's decision. So I'm just going to crack straight on. There was the last paragraph of yesterday's video talked about the line separating action behaviour that is actionable from that what is not is less than clear. So, here we go. He quotes now a case called Baskerville versus Culligan, which went to the 7th Circuit in 1995. The court in Baskerville went on to explain that the line between a merely unpleasant working environment on the one hand and a hostile or deeply repugnant one on the other is not a bright line. When it is uncertain on which side the defendant's conduct lies, the jury's verdict, whether for or against the defendant, cannot be set aside in the absence of trial error. Although Sweaty Price characterises his series of text messages to Stephanie as asking for a date and possibly a relationship, a reasonable interpretation, and the interpretation that Stephanie placed on them, is that he was soliciting a sexual relationship. In other words, the conduct alleged in this case is an uninvited sexual solicitation, which would place it on the clearly actionable side of the line, though it is not clear what would constitute an invited sexual solicitation other than a sexual solicitation by the other party. In any event, under Baskerville, Kratz's conduct would seem to meet the objective prong of the test for actionable sexual harassment, the factor most heavily emphasised by the courts in deciding whether the conduct is sufficient to establish a hostile work environment is whether there was inappropriate touching. It is also clear from the cases, however, that physical touching is not required. In Markham, another case, the conduct found sufficient to create a hostile environment in the course of law enforcement training seminars consisted entirely of comments and gestures of the instructors. And in another case called Chivers, the court held that a teacher's internet communications with a student that could reasonably be interpreted as soliciting a sexual relationship were sufficient to withstand a motion for summary judgment. A jury could also conclude that this pursuit by a person with authority over Chivers, i.e. a teacher, so undermined and detracted from her educational experience that she was effectively denied equal access to the school's resources and opportunities. Chivers decreased her participation in class, did not seek help in maths even though she needed it, and had falling grades and poor attendance. She also felt trapped into continuing to converse with Gillespie for fear that he could affect her grade and other students' perceptions of her. Chivers eventually stopped going to school altogether as a result of the circumstances created by Gillespie's conduct. Whether Gillespie's personal communication with Chivers and his repeated invitations for Chivers to be alone with him at night, either at school or at his apartment, in conjunction with the sexual nature of his screen names, the dirty cartoons, and the request for a picture to rate her as hot or not, were sufficiently egregious to support a claim for a hostile environment, is a question for the finder of facts. Similarly, in this case, Stephanie claims that Kratz's sexual solicitation of her destroyed any trust she had in the criminal justice system and led her refusal to participate further in the prosecution of Shannon Conitzer. Of course, unlike Chivers, Stephanie was not a 17-year-old high school student at the time Kratz texted her. But on the other hand, she argues that as a long-standing victim of domestic violence, she was extraordinarily vulnerable and dependent, a fact Kratz was well aware of as a result of his training and experience in prosecuting such cases. Given this vulnerability, Kratz's sexual solicitation and his attempt to pressure her to enter into a sexual relationship with him, even to the extent of using her self-confessed low esteem against her, are sufficient to support a finding that her right to equal protection was violated. The most serious difficulty with Stephanie's claim would seem to be the fact that she did not tell Kratz that his solicitation was unwelcome, that she regarded his messages as offensive, and that she wanted him to stop. In fact, by repeatedly responding to his messages, often within minutes, and sometimes with humour, Kratz contends that she continued our conversation for days with no indication that it was making her uneasy or that she wanted me to stop. Indeed, plaintiff essentially concedes the point, explaining that, quote, "I became fearful that if I confronted him too directly, it would have an adverse effect on the prosecution or cause him to retaliate against me in some other way." And of course, we know how Kratz uses people's history against them. In other words, she played along and withheld her true feelings. This is not to say that the plaintiff, Stephanie, did not actually find Kratz's steady stream of messages offensive and unwelcome, or that she did not feel frightened, threatened, and intimidated by the pressure Kratz was putting on her to have a sexual relationship with him. The fact that the plaintiff went to her mother, to a law enforcement agency in an adjoining county to report his conduct, clearly demonstrates that Stephanie truly felt pressured by Kratz and feared that he could retaliate against her by handling the prosecution of Shannon Conitzer in such a way that would continue or increase the danger he posed to her. Even Kratz does not at this point in time dispute these facts. But is it enough that Kratz's solicitations was unwelcome to Stephanie? Doesn't she have to tell him to stop or in some way indicate to him that his messages are unwelcome? In King versus Board of Regents, the court explained that sexual harassment as a violation of equal protection differs from sexual harassment under Title VII in that the defendant must intend to harass under equal protection, but not under Title VII, where the inquiry is solely from the plaintiff's perspective. How can Kratz be found to have intended to harass Stephanie if she never told him to stop sending her messages? The question of intent is directed to the underlying conduct, however, and the defendant's awareness of what he is doing, not whether he would characterise his conduct as sexual harassment himself. Stephanie has alleged facts, not refuted by the record before the court, that would support a finding that Kratz used his position to deliberately solicit a sexual relationship with Stephanie under circumstances in which he knew that, because of his position and her vulnerability, she would find his solicitation difficult to refuse. The relationship was to be, quote, secret, quote, the riskier the better, and, as Kratz bluntly stated, quote, wrong. This evidence is sufficient to raise a jury question as to whether Kratz had the requisite intent to sexually harass Stephanie as the courts have defined it. Though a far cry from the kind of conduct that those who drafted and ratified the 14th Amendment would have understood the Equal Protection Clause of that amendment to prohibit, the court cannot say that Stephanie's claim fails, given the legal landscape described above and the evidence before the court, and viewing the evidence in the light most favourable to the Stephanie, Kratz's motion to dismiss or alternatively for summary judgment on all merits will be denied. Next section, absolute or qualified immunity defence. Kratz also contends that regardless of whether the evidence is sufficient to support such a claim, because, quote, as a district attorney, he is entitled to absolute or qualified immunity. Quote, a prosecutor is shielded by absolute immunity when he acts as an advocate for the state. Moreover, absolute immunity shields prosecutors even if they act maliciously, unreasonably, without probable cause, or even on the basis of false testimony or evidence. Well, we've certainly heard a lot about that with regards to Mr. Kratz, the Sweaty Prize. Kratz contends that he is entitled to absolute immunity because, in texting Stephanie, he was in the course of carrying out the inherently prosecutorial function of contacting her as the complaining witness regarding his domestic abuse prosecution. However, not all conduct that occurs during the scope of a prosecutor's official duties is necessarily entitled to absolute immunity. The fact that government attorneys are entitled to absolute immunity when performing many of the functions of their offices should not, however, be confused with a blanket grant of immunity for government attorneys. Absolute immunity is designed to protect the functions that particular government officials perform, not the government officials themselves. Given the broad implications of absolute immunity, federal courts are, quote, quite sparing in recognising it, and there is a presumption against granting absolute immunity. Instead, courts must look to each case's particular circumstances. Simply because conduct falls within the scope of a prosecutor's official duties does not automatically mean said conduct triggers absolute immunity. The prosecutorial nature of an act does not spread backwards like an ink blot, immunising everything it touches. Where the challenged conduct occurred while initiating a prosecution, conduct will be entitled to absolute immunity only if it is shown to have been intimately associated with the judicial phase of the criminal process. Thus, courts have denied absolute immunity pertaining to conduct which, despite having occurred in the course of the initiation of conduct of a prosecution or other comparable litigation, were not an advocacy function satisfying the intimately associated test. On opposing parties in violation of the Fair Credit Reporting Act, leaving a material witness incarcerated during a lengthy continuance in their criminal trial at which he was to testify. He's quoted in various cases, countermanding the court-ordered preparation of transcripts from previous criminal proceedings for a pro se petitioner applying for habeas corpus, failing to report child abuse by a criminal defendant, orchestrating police beating of a criminal defendant. So I think we get the sense that, he's saying that, no, you don't qualify for immunity. What you did had nothing really to do with the prosecution of Shannon Conitzer, although you used the situation. Secondly, proponents must show that overriding considerations of public policy require that he be exempt from personal liability for the challenged conduct. Kratz's brief notes, historically, three considerations have been particularly important. 1. Whether there is any historical or common law basis for absolute immunity in such circumstances. 2. Whether denying immunity for the challenged conduct poses a substantial risk of vexatious litigation that would impair the prosecutor's independence and ability to function. And 3. Whether other safeguards against the challenged conduct would exist, particularly through the original judicial process, if actions for damages were precluded. Courts have also denied absolute immunity for challenged conduct where the risk of impeding true prosecutorial functions was insubstantial and other safeguards against such conduct were considered too ineffectual. Given these limits on absolute immunity and viewed under these standards, defendant has not established that pressing plaintiff for a sexual relationship through inappropriate text messages is somehow a form of conduct so intimately associated with legitimate prosecutorial functions. Furthermore, he has not proposed any meaningful overriding consideration of public policy. To the contrary, the public has quite an interest in making sure its prosecutors do not abuse their roles and take advantage of domestic abuse victims. In fact, the grant of immunity to such conduct would not bolster but rather threaten the integrity of the prosecutorial process. Defendant has also failed to demonstrate that permitting damages actions for misconduct of this kind will pose any risk of vexatious litigation that would chill prosecutors' willingness to make independent decisions about the actual prosecution of their cases or otherwise impair their exercise of legitimate professional prosecutorial functions closely related to the judicial process. I consequently conclude absolute immunity is not warranted. Defendant alternatively argues he should be protected by the doctrines of qualified immunity. Qualified immunity protects government officials from liability for civil damages where their conduct does not clearly violate established statutory or constitutional rights of which a reasonable person would have known. A court must address two questions when presented with a claim for qualified immunity: whether the plaintiff's allegations make out a deprivation of a constitutional right, and whether the right was clearly established at the time of defendant's alleged misconduct. A court may address the prongs in whichever order it believes is best suited to the circumstances of the particular case at hand. As discussed, Stephanie has demonstrated that her evidence and the inferences that can be drawn from it, if accepted by a jury, may establish a plausible claim for relief under Equal Protection Clause and its relevant precedent. In other words, there is an evidentiary basis for a reasonable jury to find a violation sufficient to deny Kratz's motion for summary judgment on plaintiff's claim. Defendant may also be held immune from liability if his conduct did not violate clearly established statutory or constitutional rights of which a reasonable person would have known. A constitutional right is clearly established if it is sufficiently clear that a reasonable official would understand that what he is doing violates that right. Previous cases need not be fundamentally nor materially similar to the circumstances, so long as it is clear that officials can still be on notice that their conduct violates established law, even in novel factual circumstances. Where a constitutional violation is patently obvious, a plaintiff may not be required to present the court with any analogous cases, as widespread compliance with a clearly apparent law may have prevented the issue from previously being litigated. So Kratz, you're a one-off. There's not many like you. Thank God for that. Mark particularly liked the comment that I said about the fact on one of the videos that I mentioned that Kratz was full of BS. I think Judge William Griesbach agrees with that comment. Here there exists enough applicable precedent that defendant should have been aware of the fact that in 20 years since Bohan, courts have generalised and reinforced the principle that sexual harassment constitutes sex discrimination in violation of the Equal Protection Clause, even beyond simply the employment context. More specifically, cases like Markham demonstrate that non-quid pro quo environmental harassment from government employees is unconstitutional sex discrimination, even beyond the employer context. Again, that case held that male DEA agents' hostile and unwelcome sexual commentary during a training session for non-employee female police officers violated the female officers' rights to equal protection, and the court specifically rejected claims of qualified immunity. Markham stated that neither this court nor any other has ever dealt with a situation involving a short training seminar conducted by narcotics officers is of no moment. Under the doctrine of qualified immunity, liability is not predicted upon the existence of a prior case that is directly on point. Given the clear intolerance of sexual harassment in the 1983 case law, as well as the broad language of those opinions and courts' willingness to extend the Bohan principles well beyond the original case, the court cannot conclude that the defendant was entitled to qualified immunity for his alleged actions. Although the specific facts of this case appear unique, the applicable principles are neither novel nor is their application here contrary to clearly established precedent. Defendant, in other words, should have been on notice as to the potential unconstitutionality of his actions. That was a long word. Unconstitutionality of his actions in light of existing case law on sexual harassment and the Equal Protection Clause. Indeed, given his concern that plaintiff not tell anybody about his contacting her and his acknowledgement that this is wrong, it is arguable that he actually knew his conduct would be considered sexual harassment. Consequently, in light of the case law discussed above, most particularly Markham, the contours of the Equal Protection Clause's prohibition of sexual harassment were sufficiently clear so that the unlawfulness of Kratz's alleged conduct should have been apparent. Kratz's argument for qualified immunity is therefore denied. Why can't I get that to come up? Let's see. Let me hold it there. For the reasons set forward above, defendant's motion to dismiss or, in the alternative, for summary judgment is denied. The clerk is directed to set this matter on the court's calendar for a telephone conference to discuss further scheduling. Signed, William C. Griesbach. Well done, William. So that concludes the motion put forward by Michael Fox against Ken Kratz. Next, we will look at the OLR decision against Ken Kratz. I've not been able to find Judge Robert Kinney's notes on the case, which are referenced many a time in that summary. So we will look at that. That'll be another multi-part exercise. Anyway, hopefully we'll catch up with Andrew over the weekend. Hopefully Derek will be able to join me. Hopefully Eric Cozy will be able to join me. Many thanks, of course, last weekend to Julie and Fen for joining me, and for Eric Cozy to showing up and showing us his lovely new drone. We'll catch you again soon. Bye for now.